In general, if something was earned or accrued or purchased during the marriage with marital income that was earned during the marriage, then that would typically be considered marital property in New York State. New York State does divide property in a divorce according to equitable distribution, so there could be a more sophisticated analysis of that or exceptions to that rule. In general, separate property would constitute those items of property that you had before you entered into a marriage, or things that you may gain during the marriage through an inheritance or trust income. But in general, the idea that just because something is in separate name does not mean that it is necessarily separate property. In New York, we operate under a concept of equitable distribution for dividing up the assets or liabilities that a couple may have amassed during their marriage. The concept of equitable distribution is based in fairness. It's not necessarily a 50-50 split, as it may be in some other states. In a litigation in New York State, there are a number of factors that a court might consider when deciding how to distribute the assets and liabilities of a couple. What's interesting about mediation and collaborative is that the parties can decide to do something other than what a court might decide to do with their assets and with their liabilities. In a divorce in New York State, when it comes to retirement assets, including a pension benefit, your spouse would be entitled to essentially 1/2 of the marital portion. So not necessarily 1/2 of the entire asset, but 1/2 of the marital portion. So if there was a time period where your spouse worked in this industry prior to getting married, or if your spouse continues working after the cutoff date of your divorce, then it will not be necessarily a 50-50 split because the entire length of the career was not during the marriage. So it would be a smaller amount. When it comes to dividing the marital residence in New York State, there are many different options that a couple may decide. Mediation and collaborative can be really great options for considering all the different possibilities, because it is not always the case that a family wishes to sell the marital residence. So a solution for a family like that may be for one of the spouses to stay in the marital residence and to buy out the other for their portion of the proceeds. One of the nice features of a mediation or a collaborative divorce is that a party can consider all of the options when it comes to their home, or what we typically will call the marital residence, whether that be for them to sell the house and to split the net proceeds, or perhaps for one of the parties to have exclusive use and occupancy of the marital residence and to then buy the other out of their share. Equitable distribution is the dividing up of your assets, but also of your debts. And so there are different ways that that can happen. For a debt to be divided evenly between two spouses, it really needs to be a marital debt, something that was accrued for the benefit of the family. There may be instances where debt can be considered separate if perhaps it pertains to a separate business of one of the spouses, or if it was accrued before the marriage, or if it was accrued during the marriage, but really for non-marital purposes. If one of the spouses to a divorce has a business or a professional practice, that may be considered a marital asset, And if it is, then it would have to be evaluated in order to determine the value of it. And then, of course, what percentage of that value might the other spouse be entitled to. When it comes to a business, there is case law in New York State that supports the idea of not necessarily splitting it 50-50, but perhaps a lesser percentage for the non-titled spouse. It is, of course, possible for a spouse to hide assets or income during a divorce. And if that is the case, then it will certainly complicate your divorce, extending not just the time, but also the costs surrounding it. Because in order to uncover those assets may require discovery and disclosure that otherwise would have been unnecessary, to send subpoenas, to conduct depositions. Those are all things that perhaps you wouldn't have to do if the parties were forthcoming with the information surrounding their assets. The existence of a prenup or a postnup agreement can dramatically impact the outcome of property division in a divorce in New York State. Parties are free to contract their way around the rules and laws that would otherwise apply to them. And so a prenup or a postnuptial agreement can be a powerful tool. A prenuptial agreement done before the marriage or a postnuptial agreement done after the marriage can be a powerful tool for the parties to use in New York State to circumvent what the law might otherwise be. Parties are free to decide to put terms into one of these agreements that could be different than what the law would prescribe to them. But if they each have their own attorney so that they have each been properly advised, they may be able to knowingly waive their right to things that they otherwise would have under a divorce in New York State.